Alright, I think we're on video 35 here. I'm going to discuss the Cestui Que Vie Acts of 1540, 1666, and move on to that act of 1707. Now, in the previous video, the legal definition of the Cestui Que Vie is he for whose life land is holden by another person. The latter is called the tenant per alter vi, or a tenant for another's life. Now, from top down, starting from English law, I would define simply that English law would be the rules that govern for he who benefits, the cestui namely, which is a cause resulting from the hierarchical system pertaining to land rights and interest. That which the monarchy holds currently and is settled through the English common law. It is settled and so refers to the monarchy can do no wrong, as this title represents the entirety of that which has been settled according to land and those titles annexed to. We move into government. Government would be considered the notice of the master-servant agreement. And a citizen would be best defined under laws of agency, who serve a quasi-trustee role, and so as a third-level tenant, who are governed under a beneficial interest and who are responsible for the wastes upon use of the land, which, of course, is all subject to English common law. The Cestui Que Act of 1540, which is the 32nd year of Henry VIII, chapter 37, there's really not much to dissect here. It was an act of Parliament that essentially ensured that an executor or administrator of a common law interest in land, whom was responsible for rents, etc., of a tenant, that if the tenant died in arrears, there was no way in which the executors or administrators could recover the arrears in rent or from fee firm or free farm when the estates pass into his heirs or otherwise. And fee farms or fee firmi, I'm not sure if that's how it's pronounced, as F-E-R-M-E, but just more or less fee farm, were an agreement essentially whereby a minimum charge of 1/4 of the value created upon the farm was due as a rent. So the Cestui Que Act of 1540 was for the recovery of the rents or fee farm before it was to be transferred over to the tenant's heirs or otherwise. Or if the heir or whomever the state went to next could not pay the arrears owed from the now dead tenant, then essentially it was held as a lien until the debt was paid. And this followed the state even if the second party of the original testator died. Now, it was an act of recovery of debts owed according to the original estate agreement. Thereby, the debt was not annulled according to the death of the original tenant. The whole act, so far as unrepealed, was repealed by Section 1 of and Part 3 of the Schedule 2, the Statute Law Repeals Act of 1969. So that act is no longer in force or effect, as it already deals with the same subject matter that was in the Cestui Que Act of 1540. This is why I repeat that law only ever seeks the agreement, so as to determine the overreach of any prior right. Law does not rule over you, the person, or the individual per se, only over the agreement you are then known to have made. The law essentially determines whom is responsible so as to fulfill an obligation according to the agreement, and also ensures to not commingle a beneficial interest with, let's say, the common law interest. Now I'm going to make mention of the Cestui Que Act of 1666, as it seems to be a go-to act so as to give the free men and sovereign movement a connection to the fact they consider to be dead in law. And thereby, I notice they're intermixing common law and law of merchants, or law of sea, and this through the use of this act entitles them a return of their estates by using the Cestui Que Act of 1606 once they prove they are alive. So let's question this concept according to the interests mentioned within the act itself. Now, for instance, I've been given a document recently explaining said act that states that serves to tie together a few papal bulls, declarations, with those interests held by the monarchy, for instance, the legal interests made under the statute uses, to which then somehow evidences 3 crowns controlling the Cestui, to which in turn rule over the birth certificate person, and then evidences that you are not seen in law because you presume to be dead at sea, until you prove you are alive, etc., etc., etc. And then there are other variations of this, to which the document I just referred to, I did not dissect it all, but only gave a general synopsis. So in case you know of said document and said, hey, I did not interpret correctly the document I'm referring to, the matter I desire to bring your attention to instead is to go to the 1606 Act itself in order to first determine the interest it is ascribing to. Namely, what is the subject matter? Remember, we discussed status and subject matter establish the jurisdiction in order to seek the determination of the remedy that you are looking according to the act that the subject matter is talking to. Now, the 1540 Act we already discussed briefly was concerning arrears of rents, etc., owing to the common law interest subject to the death of a subsequent tenant. Okay, now let's go to the 1606 Act and see what the subject matter is. The 1660 Act, first of all, is an act of the English Parliament in the year 18 and 19th year of the reigning monarch of that time. I think it was King Charles II, but that does not really matter, as this is an act of Parliament. Remember, monarchy holds a common law interest, such as the interest created through the Statute of Uses 1535, and Parliament affects rights to the equitable interest is created from the common law title. So what can this act only refer to? Survey says the equitable interest only. So let's read the act and its introduction to see what they're speaking of. Okay, the Cestui Que Vie remaining beyond sea for 7 years together and no proof of their lives, judge in action to direct a verdict as though the Cestui Que Vie were dead. It reads, if such person or persons for whose life or life such estates have been or shall be granted as aforesaid, shall remain beyond the seas or elsewhere, absent themselves in this realm by the space of 7 years together, and not sufficient and evident proof to be made of the lives of such person or persons respectively, in any action commenced for recovery of such tenements by the leaseors or reversioners. In every such case, the person or persons upon whose life or lives such estate depend shall be accounted as naturally dead. That's all I need to make reference to. It means, we just did an overview, those who are held an equitable estate as a tenant who, after 7 years, have not returned from the sea or absent from other excursion, the court will construe them as dead in the interest of the party who holds the superior interest via the lease or reversion. It is recovery of the lesser estate held by the before tenant who holds the right to the use of the land. So if you're going to court and saying you are alive and then using this said act to evidence a right to the estate interest that you are now speaking to, what must your status be? It is the lesser estate held as an equitable interest, not the legal title held in the leaseor or the reversioner. So would you consider the 1666 Act Well, best to have determined what kind of subject matter that you're trying to have determined a remedy for by stating to the court that you are alive. Those with reversion hold right to the legal title, is the one with the larger estate in common law. That is the interest held in the settler until they fully vest this interest, and so by action annul the trust and the burden held by the trustee. Now let's see what time we got going here. 10 minutes? Well, let's end this video and next video, or if I decide to make one in the interim, as I have done just based on comments that I received through Facebook are here. It will be one later, but the one that we want to go on to next would be the Cestui Que Act of 1707, because that's the one that's going to discuss the reversion according to the statute of uses 1535.